Good afternoon, everyone, and Happy New Year 2026. We welcome everyone on behalf of Avista Solicitors in today's discussion on our immigration law. Though this topic we have chosen today on fee waiver, we have already discussed about it previously, but considering the increasing numbers of FLR and fee waiver application in both combination, we find it imperative to discuss it again for our respected viewers. So for this discussion, we have got Mr. Khandakar Omar Farooq, a barrister and solicitor and a specialist in immigration law, and director of Avista Solicitors with us today. And Mr. Farooq, welcome to today's show.
Thank you very much, Joydev, and Happy New Year to you and to all of your viewers.
Thank you. As you are aware, we are seeing an increasing number of FLR applications, and one thing comes with the FLR applications is fee waiver. So if you just explain a bit again regarding fee waiver and the relationship with FLR application a bit before we delve further into the topic.
Well, to put it simply, the fee waiver application is an application. It's not a substantive application. It's an application where you don't have fee or you cannot meet your basic needs after you have paid your fee and ICE charge. And
Mhm,
it is meant to be used for applications, say, for example, like human rights application, Article 8 where involved, where children involved, private and family life involved, parental or spousal or um, this this whichever where the children and the Article 8 private family involved, this sort of application, fee application are meant to be used in that area. But recently we have seen increasing number of fee applications are being made by students, skilled worker, which is wrong.
mhm.
Mm. So
So they just cannot make fee waiver application for all the type of application in
no,
UK law.
no, no,
No.
definitely not. It's meant to be only for, you know, where Article 8 is involved.
Mhm,
Um, Family and private life, especially if you are on a private family route on 10-year route visa and your income is low, you are on universal credit or you are on benefit,
mhm,
then obviously this significant amount of application fee you can't meet. Say, for example, if you are an applicant and you have 5 dependents, and if the application is for 2.5 years, imagine how much it's gonna cost. About 15 to
yeah,
20K.
exactly.
So it's a lot of money. They can't arrange this money. If they borrow,
And,
then obviously
mhm.
they can't meet the children's need, which is like essential. That's why um, the Home Office you can apply for fewer application, and if it is can be shown that after paying this fee, your children's or your basic need cannot be met, then obviously they will grant your favor application.
All right, thank you. So if I can divide it in two sectors, first, nature of application. It must be something that relates to human rights or Article 8, whatever it is. And then secondly, there are some conditions for fee waiver application like destitution and essential living needs, all those things. That means someone who is unable to pay the fee. So they have to prove it. So my next question comes with this, that if someone is working and earning some money, can they apply for it? Because we see the clients asking this same question every single time whenever we deal with it.
Again, it will depend on their income, but obviously the clients are lay people, they don't know whether it will be met or not. But if
Hmm.
the client comes to you, you should assess their income and you should advise them. Normally, if the clients are on benefit, it's automatically they're entitled to make this application. But there could be some situation where clients are not taking benefit, still they're not earning enough. So
Hmm.
it's your duty to assess and then advise the client. Sometimes what happens, there could be partial exemption. Like they could give you, say, for example, you have to pay the application fee, not the ISS, or you
Mm-hmm.
have to pay the ISS, not the application fee. So it will depend on their income expenditure.
All right. All right, great. So, we call fee waiver application and sometimes the filler application as bridging application. And there comes, Section 3C of the Immigration Act 1971. How it is actually connected, because we have seen clients, they have just made error with it and their immigration history is gone. They are becoming overstayers and Home Office are not granting them any leave further. So if you just explain that a bit more.
Well, as I mentioned at the beginning, that this is not a substantive application, this is a procedural application, just as you said,
Hmm.
like a bridging application. So you are supposed to apply for this your application before your leave current leave expires. And if it expires and then you apply, that means you are an overstayer. Hmm. So
Hmm.
what happens if you apply? If we say, for example, 1st of January, your current leave expires and you apply 31st of December or 1st of January while the leave is valid, so you are fine. Your leave will continue. And then, say for example, down the line in 6 weeks or 10 weeks time, the FIOBA application result come up and you are not given FIOBA exemption. Then
Hmm.
you are asked to apply your main application within 10 working days. Similarly, if you are given exemption, you are asked to apply for your main application within 10 working days. So if you do that, then you are fine. Your Section 3C leave will continue.
Okay. So you have said main application and substantive application, and you are saying fee waiver as a procedural application. From our experience, we have seen people making fee waiver application first, and then without making the substantive application, they have made a separate application. I'll give you an example. They were in student visa, and then they made a fee waiver application, and afterwards, without making the substantive application, when the course completed, they directly made the graduate application and it was refused. How do you explain this situation?
Well, since, as you know, at one point, there were about 25K FIOBA application pending at the Home Office.
Hmm.
So they changed the guidelines 11th of September 2024. So what they did, they said, if you make a FIOBA application to make a human rights application, and then before your FIOBA application is decided, you varied it to a student visa or graduate visa, then you are caught by the fraud, and they will
Hmm.
you are finished. Before 11th of September, it was different. Like while the FIOBA application pending or substantive application, whatever, you could have changed it to like a student visa or a skilled worker visa. But
Hmm.
since Home Office changed this rule on 11th September 2024, if you have made an FIOBA application, whether it's granted or not, then you must make your substantive FLRO application. And then when the substantive FLRO application is pending, then you can vary it to graduate visa or student visa. Rather than if you, while the FLRO FIOBA application is pending, you vary it to graduate visa, you are caught by the fraud. You
Hmm.
will be overstayed and Home Office will never grant you visa.
Okay. So another thing I want to discuss about fee waiver application is sometimes people make fee waiver application for no reason. However, their application is rejected and then they make the substantive application. However, in a later scenario, they also changed or vary that application to their application. For example, a skilled worker application or whatever it is. At the end of the day, is there any chance that they will be caught by that fee waiver application, considering that fee waiver application as a fraud or something like that? If there
Absolutely.
is no
A-
actual ground.
Absolutely. The way the immigration's rules and law are going in this country, as you know,
Hmm.
since Second World War, the government has initiated consultation to change the immigration scenario at a wholesome basis. Now, if you look at the past immigration citizenship revocation, say for example, 15 years ago, yearly it was 2 or 3. Now,
Hmm.
you will see 3-digit number. every year, hundreds and hundreds British citizens who are naturalized, they lose their citizenship because they are caught by the fraud. In the past, when they claim asylum, they said one thing. Now it came to light to the Home Office that that was lie, and
Hmm.
that's how they are catching people. It will not be impossible if you say somewhere in your immigration history one lie, and later they find it, then you will be caught by the fraud. It doesn't matter. You have got British citizenship, you are nationalized. Still, they can bring it. One simple lie will ruin your whole life.
All right, great. I think we have clarified those issues. I mean, the important issues regarding which we get questions from the clients every single day whenever there is a FLR application. I believe this helps everyone. And as you can see, I mean, my words to the respected viewers that these few waiver application and the FLR applications, they are very complex and they're also sometimes interrelated. So it's better to get some expert legal advice from a proper solicitor or a public access barrister or whoever is allowed to practice the immigration law. So without this, it will be really complex issue to get understood by the lay people. I mean, the law in this area is quite complex. So yeah, we suggest getting proper legal advice before that. So yeah, thank you, Mr. Farooq, uh,
Sorry, if you allow me,
for your
just
discussions.
I want to add just one thing.
Of course,
As
definitely.
you know, even for students, it's not impossible to get if you have an application granted. We have done it in the past. The most
Hmm.
important thing, you have to be honest and tell the truth in the cover letter. And as you know, we have done for several students fewer application, and they were granted because um, they were like a genuine case, and they didn't have money, and it was
Hmm.
compassionate and compelling reasons. They had to apply for fewer and granted. So the most important thing when you apply for paper application, you have to be honest. You have to mention all your bank accounts because they will ask for the statement. And also,
Hmm.
you have to give the honest reason why did you apply for paper application. Then I think you will be fine. But it's a complex, as you said. But if you get a proper legal advice and assistance, then I think you are not caught by the fraud rule.
Yeah.
Thank you.
Great.
Thank you.
I think that helps even more. So yeah, thank you, Mr. Farooq, for joining us today. And thanks to all the viewers who are seeing it in Facebook, YouTube, and in our Avista Solicitor space. If you need any help, any expert advice, you can contact us via email or phone number, which is given in the description box below. So thank you, and thank you, Mr. Falk, again, and Happy New Year to you again.
Thank you so much. Thank you, everyone. Thank you. Happy New Year to